Mr. Andrew Crawford. I see him. Good morning, sir. And we should have Ms. Lori Marie Benoit Knox. And I see you here as well. Good morning, Mr. Crawford. I see you unmuted yourself. Excellent. And if you're ready to proceed, please go ahead.
May it please the court. Good morning, Your Honors. My name is Andrew Crawford. Judge Kazam, I would respectfully ask for 5 minutes of rebuttal time.
Very good, sir. Whenever you're ready, we are ready.
Again, good morning, Your Honors. My name is Andrew Crawford. I'm here on behalf of the appellant in this case, Armando Rodriguez Oliveira. This case comes to the court after a conviction and a resulting life sentence for capital sexual battery and 2 counts of lewd and lascivious molestation. I raised a number of issues in this appeal. The 3 issues that I'd like to speak with Your Honors about this morning is the admission of an uncharged collateral crime of child molestation or attempted child molestation, the restriction on defense counsel's ability to cross-examine the complainant in this particular case after the state opened the door, as well as ineffective assistance of counsel on the face of the record pursuant to Bodo versus State, which I filed on, which was ruled on by the 3rd DCA after both the answer brief and the initial brief were filed.
Mr. Crawford?
Yes, ma'am.
I want to ask you a question. I appreciate your outlining for us. I also want to hear from you about the 3850 denial with respect to the exclusion of KP as a witness.
Yes, Your Honor.
So you have a limited time and I don't want for you to lose track of it because I have some questions for you about that.
Yes, Your Honor. I will try and get to that. As it relates to the first issue, in this particular case, I think the court and the case law requires the court to examine this in terms of harmful or harmless error under the proposition that there was no physical evidence, there was no medical evidence, there was no admissions, there was no type of Williams rule evidence, which you frequently see in these type of cases. And as a direct result, the only evidence in this case against Mr. Rodriguez Oliveira was the complainant's statements. Therefore, the admission of the uncharged collateral crime, which in this particular case was an attempted lewd and lascivious molestation, came before the jury twice. Once during the testimony of the child protection investigator, Ms. Harmon.
And when that happened, your client's then counsel conferred with your client and everybody understood that it sort of came out unexpectedly. And after a conference with your client's counsel affirmatively waived a mistrial, took a curative instruction and moved on. And we here are bound by an abuse of discretion standard of review. Is a fleeting reference it would be one thing if your client had moved for a mistrial and it was or your client's counsel had moved for a mistrial and it was denied, but this is troublesome. So I need you to address that part of it, the affirmative waiver of a mistrial.
I absolutely will. I think it must be viewed in the context of this coming again before the jury during the CPT video, which is on page 272 and 274, or excuse me, 258 and 259 of the record itself. So you have it coming in once, a curative instruction is given by the trial court. Then you have it given a second time the next day. The implication clearly on both of those questions is it's an uncharged act of child abuse or child molestation. The question specifically is, at least as to the second one, are there any other times or any other incidents with Armando? Right before that, the complainant in this case was talking about oral sex. The response that the jury heard was, this is the second time he tried to get me. And again, she references the living room, the TV touching her down there. So it's the same incident. And she specifically says it's after the movie incident. So you have a jury.
But would you agree, Mr. Crawford? Let me go back to the very first one.
Certainly.
When the judge gave a curative instruction, it was a pretty powerful statement to hear from a judge saying, there is no other incident. You are totally to disregard that. That's pretty strong for the judge to affirmatively say, members of the jury, there's nothing else. can't that imply almost like it could be an issue as to the declarant's credibility? Because here's the declarant, here she is testifying, Ms. Harmon, and then about, oh, there's this other incident, and then you have a judge saying there's no other incidents, disregard that. Doesn't that kind of play in the benefit of your client that you have a judge affirmatively saying there's nothing else? And then for the second one, you have to look, if you have to listen to the whole tape. It could be argued that she was not really referencing a second, it deals with that whole incident in terms of the time sequence. And just want to have your take on that, Mr. Crawford.
Certainly, Judge Kazam, and also this kind of ties into Judge LaBritte's question. No, in terms of your answer, this court and other courts across the state of Florida have made it expressly clear that there are certain times when a curative instruction is insufficient to cure the prejudice, such as which occurred here. Furthermore, if the court finds that at least that first portion is waived based on trial counsel's response, I would submit that it's fundamental error pursuant to the Fight case and the Mendez case, which I've cited, which are especially the Mendez case, which is almost virtually indistinguishable from the case that we have here. Judge Kazam, in response to your question, he could have given a even lengthier and even more powerful curative instruction here. And it still would not have cured the prejudice because of, as the third district noted, the societal outrage and the stigma attached.
Well, you're going into your discussion of the Mendez case. And just to be clear, I disagree with you that it is indistinguishable from this case. I think the evidentiary issues in Mendez were far more egregious than what we have here, and that the facts were distinct. And I get that that's your argument, but I would like for you, I want you to have enough time to address all of the errors that you have complained of. And if you've answered Judge Kazam's question sufficiently, I'd like to hear about the rest of the errors.
Yes, I will. With that instruction, I will definitely move on. The second error is the ability to fully cross-examine the complainant in this case, which is a Sixth Amendment right guaranteed by both the United States and the Florida constitutions. The case law has made it expressly clear when it is a credibility contest, especially in a case like this where there's literally no other evidence.
So cutting to the chase on this argument, you rely principally on the Pantoja case and the Dosical, whatever, I don't know how to pronounce that name, from the 5th DCA, right? Those are your key cases.
Pantoja is not the case I specifically rely on. That is a case the judge used to exclude the evidence, which I would note the state does not even mention in their brief or cite, therefore hinting as to.
And what Pantoja stands for is that you can cross on a victim's prior false accusation of sexual molestation in this context. And here, the prior accusation turned out apparently not to be false because Mr. Mendez, forgotten his name, Joey, pled to the charge that this victim made against him. And your other case, the 5th DCA case, is where this woman accused a married man of raping her, and she said she let him sleep in her room, which is when he raped her, because he was married, and therefore he wouldn't be assumed to be of the mind to have sexual relations with her. And then the error that occurred was the exclusion of evidence concerning the victim having slept with a married man the night before the alleged rape. This is a lot different because the issue that you're going to is the Martinez incident, and this victim accused him of it and he pled. So this is not where, you're challenging the victim's credibility for making false accusations or her credibility as to this accusation based on some prior conduct. And then you get to the point of, well, the state opened the door to it by publishing the video, and that your client should have been allowed to impeach the victim for lying about Martinez, which wouldn't work, or to confront the victim as to whether she confused the Martinez incident with the incident with Armando. So help me out here, because I don't see a way to get there from here with the authorities that you're reliant upon and the principles that you're reliant upon.
Certainly.
And what would have been elicited, your opponent argues that this wouldn't have helped at all. In fact, it would have corroborated their case. So help me out with that.
Certainly, Your Honor. And I think what is key here is to actually look at the questions asked and the response given, because there's actually two. Okay. The first question comes on page 272 of the record. And specifically, the question is, besides Armando, has anything happened to you like this? Has anything happened like this with anyone else? Okay. And right before that, the CPT investigator is talking to her about touching of the breasts. Okay. So you have that in context when clearly she accused somebody else. Then you flip on to page 274, and she's being asked about whether she's scared to go home or scared to be around people. And she said she's scared to be around guys because she's scared that someone might do something to her. The question then becomes, has anyone else done anything like that? And the answer is no, when in fact it had happened. I think it's crucial. It goes to her credibility because she's saying something didn't happen with somebody else when in fact it did. It clearly did. It goes to her credibility. Her credibility is a key issue in a case like this when you have no other
you
evidence.
Understand, though, your opponent's argument is somewhat persuasive here, which is that, cross-examining this victim to dive into the details of her situation with Martinez would, in all probability, not have helped your client.
I respectfully disagree with that argument, Your Honor. The fact is, she said nothing else happened when it specifically did. So
you basically, or the sword you're going to fall on here is that since it's he said, she said, this would have given your client the opportunity to somehow call out a lack of credibility, which would have placed your client in a more favorable position with the jury.
Exactly right.
Okay.
And that's what the case law says. I'd also direct the court to the Thorne case, which is 271 Southern 3rd 177, which is also a very which I would assert is a similar case. Judge, in that particular case, the court excluded evidence of prior sexual batteries during the CPT video. Then the complainant testified, said that she was, potentially scared of the defendant in that particular case, and the court said that although it was harmless error, said that should have been admitted to impeach the actual victim in the case, which is very similar to what we have here. And I respectfully submit that case applies, and the court should use that case as persuasive authority to find that the Confrontation Clause rights of Mr. Oliveira were not properly, adhered to. So I'd respectfully ask the court to reverse on that basis as well. The third issue is whether trial counsel was ineffective. Now, I am not conceding this, and I'm definitely not conceding it, as I mentioned in the reply brief. If this court finds that these issues were not preserved for appeal, as it relates to the collateral crime evidence, also as it relates to the child hearsay, as well as the blatant comment on the defendant's right to counsel and right to remain silent, the lack of the moving for a mistrial, I respectfully submit that the trial counsel was ineffective on the face of the record pursuant to the Bodo case and other cases that I've cited within my brief.
I mean, we could go down a whole rabbit hole with that one comment on the defendant's silence that the deputy made in response to defense counsel's questioning. But I think I speak for my colleagues when I say we've read the briefs and we've read the record and the ancillary materials, the legal authorities that you've cited in the briefs. You're about to run out of time on the main, and I would like you to address the issue of the failure to call KP on the denial of the 3850.
Certainly.
Please.
I will. Thank you, Your Honor. Your Honor, this appeal was consolidated. The court allowed Mr. Rodriguez Oliveira to file a 3850 while this case was pending. There was newly discovered evidence, and specifically, the investigator found evidence that the complainant in this case recanted her allegation. I won't say recanted, but basically said that Mr. Oliveira never touched her when she was talking to her grandmother. This was persuasive evidence. Trial counsel should have at least tried to reach out to this individual, and the court should have granted an evidentiary hearing on this particular issue.
So your opponent's position on this is that your client has taken mutually exclusive, inconsistent positions with regard to when the information about KP became available. On the one hand, your argument has been predicated on the notion that she was discoverable during the trial, and on the other hand, the argument was that nobody knew about KP until after the trial. Can you address that, please?
And Mr. Crawford, you are about to go into your rebuttal time. Just wanted to alert you of that, okay?
I'm going to reserve the balance of my time. Actually, Judge LaBritte, regardless of whether she was before or after, it is very important that the jury should have heard about this particular evidence when you have such a close call, such a close evidentiary case, where there is absolutely no physical evidence, and there's another witness who says that she overheard the alleged complainant in this case say that it did not happen and Mr. Oliveira didn't touch her. I respectfully submit that should be remanded for an evidentiary hearing, as it is not conclusively refuted by the record. Judge Kazama, I reserve the balance of my time.
Very good. So you have 4 minutes left for rebuttal.
Thank you.
Thank you. And I'm going to ask you, Mr. Crawford, if you could mute your microphone, and then Ms. Benoit Knox, whenever you're ready, ma'am, the court is ready to proceed. Okay.
Good morning, Your Honors. My name is Lori Benoit Knox, and I represent the state of Florida in this matter. Starting with issue 1, indeed the first comment, there's a few things that need to be emphasized. First of all,
Ms. Benoit Knox, can I have you flip that and address Mr. Crawford's last statement with respect to KP, if you don't mind? Because
sure, Your Honor.
One of the things he raised in his brief is the fact that the court totally dismissed it outright without even having the evidentiary hearing to make a determination as to when that was done. When was it? When the time seems to be an issue as to when KP surfaced. Don't you think that it would be more appropriate for the court to have an evidentiary hearing to determine whether or not the timing as to when KP, in order whether or not to make the decision to allow that or not? Can I just have you address that, please?
Well, I think what the court found is, and it's not, I will agree that it's not the clearest order, but I think the court found also that the allegation was facially insufficient. Because there is no clear mention of when the statement was made, that it was reported to trial counsel, that the witness was available and willing to testify at trial. I think none of that is in the motion. And so because it was facially insufficient, after counsel had been given opportunities to amend that motion, I think that's the reason this was summarily denied. There's also indeed in the order comments as to the merit of it, but I think that's secondary. I think the inquiry ends here because it was facially insufficient. So there was no need for a hearing on a facially insufficient motion.
All
right. If I can move on to other issues, if the court has no other question as to this specific one, I will again, everything I can tell the court has read the briefs, and indeed, I do not believe that appellant should be allowed now to argue that the testimony of KP is newly discovered evidence, when what was alleged below was that trial counsel was ineffective for not bringing it in.
Well, doesn't that whole dichotomy sort of point up the ineffective assistance of counsel?
I'm sorry.
Our defendant is not, these weren't his direct acts, these are ineffective assistance of counsel. And the fact that the lawyer seems to have bungled the framing of the request for 3850 relief in a way that made it somewhat difficult for the trial judge to reconcile whether to have an evidentiary hearing. In a way, you look at this and it's like, yeah, this lawyer was ineffective. I mean, there several of the points that are made are compelling, but they're legally.
But then I'm sorry, I don't know if you have, then we're talking about the ineffectiveness of post-conviction court counsel. We're not talking about trial counsel anymore. And I believe there's case law there that says there's no 3850 for the 3850. So I think that's I think it's actually a different attorney, but also it's a different trial. It's not the trial anymore. It's the post-conviction.
But part of it is the trial, because KP wasn't, under one view of this, trial counsel didn't get KP in the act, okay, to be at trial. And then post-conviction counsel messes it up with, well, we just found out about it or whatever. So it's a little bit of a Gordian knot to my way of thinking, but either way, there's a good argument that the defendant hasn't had effective assistance of counsel.
Well, respectfully, I would disagree. Procedurally, we don't even have the allegation that trial counsel even knew about KP. So because
well, that's my point. Trial counsel should have known about KP, shouldn't he?
Not if we don't even know when KP's statement was made. If KP's statement
and that sort of goes to Judge Kuzan's question about shouldn't there have been an evidentiary hearing?
And my answer to that is, if the motion is facially insufficient, the trial court does not hold the post-conviction court does not hold an evidentiary hearing. So the state's position is that no, that was not error. This was not properly alleged, and the court was correct when it denied that motion. As to the other issues in the brief, as to issue 1, this was not the collateral crimes that we're talking about were not developed. They're just hints. There's no evidence about it. They're not hints that somebody else also accused the appellant. There's just hints that the child said there was another incident. They were not highlighted. They were not argued by the state. They really did not. And the first one is met with a curative instruction that was accurate and pretty powerful. The state disagrees that Mendez or Fike are similar. The allegations, what happened in Mendez and Fike, is way more egregious and damaged appellant's case. Those appellant's cases were more than what happened here. As to the cross-examination issue, first, I think this court has grasped that, but it bears repeating that this was not a false allegation. This was a verified allegation that other person did admit to molesting the child and was convicted. And so outside of the issues that the state does not believe the child opened the door, the other thing, as to the extent that this is argued as a credibility argument, I think it's important to realize that the state had redacted that tape. In that tape, the child did disclose the molestation of Mr. Martinez. So it's a little disingenuous to say that the child was lying when it's in the record. The state says that other molestation was in that tape and was redacted. So when the child answered that no, nothing like this had ever happened to her before, in her mind, it's clear from the fact that she had in that same interview disclosed what happened with Jose Martinez, that what happened with Mr. Martinez and what happened with appellant to her were not the same thing. So she did not open the door. The state did not open the door, even if this court found that it did. As stated in the answer brief, the state fails to see how that would have helped appellant's case for the jury to hear that there was a verified a verified prior incident where this child told the truth and that person agreed that she had been molested. Appellant relies on Thorne. However, in Thorne, this was the theory of defense. It went to the heart of the theory of the defense that the child had at some point accused other people and not accused him. But additionally, outside of those differences in facts, I want to point out that in Thorne, the court ends up finding that the error was harmless. And in doing so, it states, had appellant cross-examined the victim about the people who had sexually molested her, there's a reasonable probability the answer could have engendered empathy from the jury for the victim, thereby increasing her credibility. So even Thorne supports the state's position on that issue. As to the ineffectiveness on the face of the record, the state disagrees that there is that in this case, the first collateral comment was met with a contemporaneous objection, a curative instruction, and trial counsel affirmatively said after consulting with his client that he was not asking for a mistrial, which can reasonably be interpreted as a trial strategy. As to ineffectiveness based on the other issues, if this is properly, the state would first know that this is not properly before the court. It was in the title in an issue, initial brief, but was not argued and appeared in the reply brief. In any case, those comments also, those issues also do not rise to ineffectiveness on the face of the record. Appellant relies on cases that are distinguishable. The Boto case is completely different. First of all, that case is on a 3850 and not on the ineffective on the face of the record. And in that case, the collateral crime that came in is much more egregious than the charged crime. And there's William Rule's evidence that the court hints was improperly admitted that corroborates the Williams Rule evidence. So the facts are completely distinguishable. And in that case, that trial counsel had never objected to anything, which is not what we have here. As to the silence, appellant relies on Howard. However, on Howard, the silence was mentioned by the state in opening statement. Extrinsic evidence was introduced when an officer was questioned about it. It was heavily emphasized in closing argument and again in a rebuttal argument. This is again not what we have here. And so for all these reasons and everything that is stated in the answer brief, the state would ask this court to affirm the convictions and sentences. And if there's no other question, I would rely on the merits of my brief.
I don't believe there's any other questions. Thank you, Ms. Benoit Knox. If I could trouble you to mute your microphone, and Mr. Crawford, you do have your 4 minutes for rebuttal. So whenever you're ready.
Thank you, Your Honors. Judge Kelly, Judge LaBritte, and Judge Kazam. The important thing that the trial court did here in terms of KP during the denial of the evidentiary hearing is the court made a conclusion that because KP was not interviewed until after trial, it was impossible for defense counsel to present her testimony. That's not correct. Appellant specifically alleged on page 1034 and 1035 of that record, as well as 1036.
Let me ask you a question, Mr.
Certainly.
Crawford. The trial court in the order said defendant failed to demonstrate that the testimony would come into trial. And so tell us how KP's testimony would have been admissible.
It would have been admissible specifically either as a prior inconsistent statement when properly confronted. Isn't it true that you told KP on such and such date that, or told your grandmother on such and such date that KP overheard you say that Mr. Oliveira never touched you? There's a number of evidentiary ways that could come into evidence. Furthermore, I think it would come in substantively as either as a prior inconsistent statement or during the defense case in chief. Again, there would be a number of ways it could be introduced. So it absolutely could have been introduced.
And the reason I ask that is if we do send this back, we want to be able to give some guidance to the trial court as to the expectation for such a hearing.
Certainly.
So now is your time to tell us what you want us to know about that.
Yes, of course, Your Honor. The defense counsel could specifically confront KP with her statement to her grandmother. If she admits it, that she said she was not touched, that's evidence. Alternatively, if she denies making such a statement, the defense could call KP as a witness to impeach her actual trial testimony after being properly confronted with it, as a prior inconsistent statement would be one way. So that is the chief way that I think it would come into evidence. To specifically note, defense counsel said and alleged in the motion for post-conviction relief that he requested trial counsel contact certain family members who would corroborate the fact that the accuser was fabricating the allegations. Furthermore, the names of the specific witnesses not called included KP. Mr. Oliveira requested defense counsel speak with these individuals and all the other individuals who were present at the time of the alleged events. And Your Honors, that's on page 1036 of the record. So the court's conclusion that it was impossible to interview KP until after the trial is not supported by the allegations contained within the 3850 motion. Therefore, they're not conclusively refuted by the record. Furthermore, the hearsay rule can, under Chambers versus Mississippi, cannot act as the evidence code cannot act as a bar to otherwise inadmissible evidence, which I would submit if the hearsay exception of the prior inconsistent statement, that this would be a situation where that could possibly apply. There also might be a chance that she said, I don't remember saying that, and that would also allow the testimony in. So I respectfully ask that this court reverse and remand for a new trial, find that the Confrontation Clause rights were violated, find that an inadmissible collateral act of child abuse came before the jury, as well as find that the 3850 motion was not conclusively refuted by the record, especially as it relates to KP's allegations.
Mr. Crawford, this is amazing. You are exactly on your 4-minute rebuttal. So you nailed it in terms of all your points on rebuttal. All right. Very good. Thank you both. Thank you both very much. I'm going to ask you at this time now to simply exit while we call the next cases on the